Good evening, everyone, and welcome to tonight's presentation by Professor James Anaya entitled The Rights of Indigenous Peoples in the Contemporary World, see the power of ideas and the challenges of implementation. My name is David Peets, and I'm from the University of Arizona. And you might be asking yourself, why is somebody from Tucson introducing a speaker here on the River Point campus? More on that in just a second. I'll explain that in a little bit. But first, I want to thank several individuals and organizations who are sponsoring tonight's presentation. I'd like to extend a sincere thanks to the Thomas Foley Institute for Public Policy and Public Service at Washington State University. And thanks to Richard in particular for helping us to organize this. And a big shout out to Dorothy Zeisler-Vralstedt right here from Eastern Washington University. And really it was Dorothy who was the extraordinary force in organizing this event. I'd also like to thank the Center for Environmental Research, Education, and Outreach at WSU, and to Amanda Boyd, who also was of a great help in organizing this event. And I'd like to also thank the College of Humanities at the University of Arizona. So our event is really the first activity of a 5-year teaching and research project entitled Indigenous Peoples and Water. And this is a collaborative project between Eastern Washington University, Washington State University, and the University of Arizona. And the project is sponsored by what is called the UNESCO Chair in Environmental History, which is located at the University of Arizona. And indeed, Dorothy from Eastern and myself from the University of Arizona are co-directors of this project. The research, I'd like just to tell you a little bit about our project. The research and teaching activities of the Indigenous Peoples and Water Initiative focuses on the historical trajectory of the contemporary relationship between Indigenous peoples and water in regions around the globe, including the Pacific Northwest and the American Southwest. And obviously we couldn't be more pleased to kick off our research project than by having Professor James Anaya speak on really a broad set of issues that are so central to our project. So in either event, if you'd like to hear a little bit more about the UNESCO Chair and our research and teaching projects, please don't hesitate to let Dorothy know or myself know after the presentation or whenever, and we'd be happy to speak more. Well, forgive me for all the prefatory comments and allow me just to go straight to the introduction of our speaker. James Anaya is the Regents and James Lenoir Professor of Human Rights Law and Policy at the James Rogers School of Law at the University of Arizona. Professor Anaya teaches in rights in areas of international human rights, constitutional law, and issues concerning Indigenous peoples. Among his numerous publications is his acclaimed book, Indigenous Peoples in International Law, which was published in 2 editions by Oxford University Press, and his widely used textbook, International Human Rights, Problems of Law, Policy, and Process. More recently, he served as the United Nations Special Rapporteur on the Rights of Indigenous Peoples from 2008 to 2014. Professor Anaya has advised numerous Indigenous and other organizations from really around the globe on matters of human rights and Indigenous peoples, and he has represented Indigenous groups from many parts of North and Central America in landmark cases before courts and international organizations. Among his noteworthy activities, he participated in the drafting of the United Nations Declaration on the Rights of Indigenous Peoples and was lead counsel for the indigenous parties in the case of Aguas Tingni versus Nicaragua, in which the Inter-American Court of Human Rights, for the first time, upheld indigenous land rights as a matter of international law. As UN Special Rapporteur on the Rights of Indigenous People, Professor Anaya monitored the human rights conditions of Indigenous peoples worldwide, addressed situations in which their rights were being violated, and promoted practical measures to secure Indigenous peoples' rights, traveling frequently to meet with government officials and Indigenous communities. Prior to becoming a full-time law professor, he practiced law in Albuquerque, New Mexico, representing Native American peoples and other minority groups. For his work during that period, Barrister Magazine, a national publication of the American Bar Association, named him as one of, quote, 20 young lawyers who make a difference, end quote. He's also been a visiting law professor at Harvard Law School, the University of Toronto, and the University of Tulsa. Professor Anaya is a graduate of the University of Mexico and received his law degree from Harvard Law School. So we are absolutely delighted to have Professor Anaya join us this evening, and without any further delay, please join me in extending him a very warm welcome to the Riverville campus.
Good evening, and thank you very much, David, for that kind introduction. It's really my pleasure and honor to be here with you this evening. I want to thank the Foley Institute, Eastern Washington University, and the UNESCO Chair on Environmental History for the opportunity to come here and share some thoughts with you this evening. The UNESCO Chair project, as I understand it, focuses on, and as Professor Pites just explained, focuses on Indigenous peoples and water in particular. I want to step back and take a look at the broader issue of Indigenous peoples as the issue has arisen at the global level, and examine some of the responses, or the major responses at the global level, to the demands of Indigenous peoples for recognition and protection of their rights over lands, natural resources, culture, and other matters that are important to them and their development. And then I'm going to talk about some of the difficulty in implementing these fairly newly recognized standards that are protective of Indigenous peoples' rights at the global level. If I can get this to work. On September 13, 2007, the United Nations adopted the Declaration on the Rights of Indigenous Peoples. I actually took this picture here. I don't know how well you can see it. I'm very proud of it. I had just acquired an iPhone and I flipped it out, and there it is. But this is the instant in which the General Assembly members, the member states of the United Nations, took the vote. And you'll see an overwhelming majority of the UN member states voting in favor of the declaration. The voting board up there is the vote tally, showing 143 votes in favor, 11 abstentions, and 4 against, one of them the United States, the other Canada, New Zealand, and Australia. More about that in a minute. But nonetheless, at this very moment, the world passed from a time when having a declaration on the rights of Indigenous peoples, a declaration affirming Indigenous peoples' place in the world and the rights to lands, resources, and to a dignified life, a moment in which that passed from an aspiration to a reality, when the claim to have rights recognized at a global scale was just a claim to a time in which the world, through the United Nations, recognized in a formal sense a series of standards protective of Indigenous peoples' rights. The Declaration is premised on the recognition of historical oppression against Indigenous peoples, beginning with and going before, or since before, patterns of colonization in the Western Hemisphere and other places. A history of oppression that resulted in the taking of Indigenous peoples' lands by settlers and colonizers, that resulted in the undermining of Indigenous peoples' cultural patterns and social pathologies that continue today. Upon this premise, the Declaration articulates a constellation of rights that are deemed inherent to Indigenous peoples, that are based on broad principles of human rights, as we're going to see, and that are acknowledged to have not been respected in the context of Indigenous peoples. So with this history of deprivation of rights, the acknowledgement of rights today, the Declaration then calls upon the international community and states to take joint and separate action to remedy that historical deprivation of rights and to put in place a series of programs that will address those concerns of Indigenous peoples that have arisen through that historical deprivation of rights. What's important to understand is that the Declaration was a matter of debate over a number of years. That is this particular instrument. At least 25 years since the first efforts to draft this instrument occurred. And there was debate among Indigenous peoples, between Indigenous peoples and governments. And little by little, we could see governments accepting the idea that Indigenous peoples have rights, collective rights, and the right to a dignified existence through the future. Yet in the end, as I mentioned, there were 4 countries that voted against, and one of them was the United States. But what's noteworthy is these countries did not oppose the basic principles of human rights that are in the Declaration. It was more the wording that was found or is found in the Declaration. They read into the wording of the Declaration extreme interpretation. For example, many or some in the United States Declaration, and the United States delegation and the Australian delegation to the United Nations said, well, if we recognize Indigenous peoples' inherent or original rights to lands and resources, that means we have to give the whole continent back or give all of the country back. Of course, that's an absurd reading. Finally, sober minds prevailed. Of course, changes in governments, elections matter as well. And so in 2010, the United States became the last of these 4 to reverse course and support the Declaration on the Rights of Indigenous Peoples, and did so really at the urging of tribal leaders in the United States. That urging on the part of tribal leaders in the United States really represents a movement by Indigenous peoples globally, a movement of political dimensions, of social dimensions, that entails Indigenous peoples from various parts of the world coming together, articulating their common concerns, and promoting a response to their rights. A movement that has come to be known as the International Indigenous Rights Movement, that is based in substantial part on the forging of a common identity with particular issues and problems centered around this history of colonization and oppression, and then the positing of the need for remedial action in order to address those legacies, the legacies of that historical colonization and oppression. This historical movement this international Indigenous rights movement can be seen as having certain antecedents before the modern era of advocacy at the international level. Antecedents that include the efforts of Iroquois Chief Descahe before the League of Nations in the 1920s. The League of Nations, as many of you know, is the predecessor institution to the United Nations. It was a failed attempt at world organization. I say failed because it was instituted at the end of World War I as a response to the global turmoil that World War I represented, but failed to avert a second World War and came to an end as the Second World War came into place. But during that period of the existence of the League of Nations, Descahe went to the seat of the League of Nations in Geneva, taking the case of his people. Now, at that particular point in history, the international system was not open to individuals or others who were not representatives of recognized nation states. Now, Descahe said he represented a nation state, the Iroquois people. Yet his claim was opposed, as you would expect, by Canada, Great Britain, and others. And of course, had he been recognized as representing a nation state, that would have had a lot of implications for many of the members of the League of Nations at that time. So he was greeted as a curiosity. You can go to the seat of the United Nations today in Geneva and see photos of this Grand Chief with full headdress next to diplomats from various countries of the world. And you could see them, almost see in their faces a reveling that they are there with a real Indian chief. Yet that was pretty much as far as things went. He was received, in some sense, courteously, but in another sense, shown the door, because his claims could not, within that system that then existed, find a footing in order to take hold and build into a response to those particular demands that were being put forward. Fast forward 50 years or so to the 1970s, when Indigenous peoples throughout the Americas in particular, faced with insufficient or inadequate responses to their claims at the national level, appeal again to the world community, this time through the United Nations, which came into being at the end of World War II, another attempt at world organization in an effort to avert conflict toward the future, an attempt that at least still is ongoing, as we know. The United Nations now incorporates an explicit concern for human rights and allows for certain levels of participation for individuals or groups, experts, and other entities that are not themselves representatives of governments. And so with this concern for human rights, and with this opening for others than representatives of governments, Indigenous people found a foothold, found an opening, and in some degree, fertile ground for their claims, especially to the extent those claims could be posited in terms of basic human rights. An historic event was the 1977 NGO Conference on Indigenous Peoples in the Americas, organized by a series of non-governmental organizations, an event at which were present Native American representatives, First Nations representatives from Canada, Indigenous peoples representatives from throughout the Americas. And what came from that meeting was a common theme of self-determination from the participants, a common demand of self-determination related to deprivation of self-determination in multiple ways within their home countries. Now, this movement of Indigenous peoples led to the formation initially of the United Nations Working Group on Indigenous Populations. This was the first United Nations institution specifically focused on Indigenous peoples' concerns. And it was an outgrowth of this 1977 NGO conference. It was one of the proposals of that conference to have an entity, an institution within the United Nations system specifically aimed at Indigenous people's concerns. Now, this working group was at the very lowest rung of United Nations organizational hierarchy. If you can imagine an organizational chart with various institutions subsidiary to the others, you would imagine the lowest rung within that organizational chart, and this is where this working group on Indigenous populations was. Nonetheless, Indigenous peoples took advantage of this institution. It was a working group of 5 individual experts appointed by a subcommission of the Commission on Human Rights, which is a subsidiary body of the Economic and Social Council, which answers the General Assembly. But this relatively low level, or many would say lowest level working group, opened its doors to Indigenous peoples and allowed Indigenous peoples to express themselves within the deliberations of the working group. The working group had a relatively modest mandate. One, to receive information from Indigenous peoples about their conditions. Secondly, to develop new standards that would relate to their rights and be protective of their rights. And it was only a deliberative body. It didn't have the power to make any decisions about these matters that were being brought to it or about the development of a new instrument. It had the power to talk about it and maybe propose new standards that would then be acted upon by the parent bodies of the working group. But Indigenous peoples took advantage of this opportunity to express themselves, articulate their concerns in ways that resonated across the world. Again, we saw common themes of self-determination, of rights over lands and resources being expressed by Indigenous peoples, and stories about the deprivation of those rights, and the consequences of the deprivation, of the historical deprivation today, the social pathologies that existed, the suffering that many Indigenous peoples were experiencing as a result of those historical deprivations. These things came out in the deliberations of the working group. And they fed into that other aspect of the working group's work, which was the development of new international standards. These stories that Indigenous peoples expressed helped illuminate what a new international instrument would look like, what kind of issues it would address, what kind of standards it would embody in order to address those concerns of Indigenous peoples. And it was eventually the work specifically of this particular body that led to the initial drafts of the Declaration on the Rights of Indigenous Peoples, which was then approved up the chain all the way up to the General Assembly, as we've seen. Now, complementing the activities of the UN Working Group on the Rights of Indigenous Peoples was the increasing use of international complaint procedures by Indigenous peoples. Indigenous peoples began going to the various institutions, mechanisms that exist within the UN system, the committees that are connected with various human rights treaties which receive information, including complaints about human rights concerns, Indigenous people started using those to express their concerns in terms of basic human rights, rights to culture, rights to equality, rights of due process in connection with their particular concerns. Also, Indigenous peoples used increasingly the regional human rights bodies, particularly the bodies connected with the inter-American human rights system that's grounded in the Organization of American States. The case that David mentioned that I was lead counsel on, the Awastini versus Nicaragua case, was a case that was initiated within the Inter-American Commission on Human Rights and went all the way up to the Inter-American Court of Human Rights. And increasingly these bodies provided opinions, in some cases formal decisions, in other ways simply encouragement for Indigenous peoples in affirmation of their rights and interpreting these basic human rights in a way that interpreted these basic human rights concerns in a way that was responsive to their particular conditions. And so through these various efforts, we see a global Indigenous rights movement gaining ground and eventually leading to this recognition on a global scale of Indigenous peoples' rights that's represented most prominently today by the UN Declaration on the Rights of Indigenous Peoples. A remarkable thing, I think, a remarkable thing. One could ask, well, how did this happen? How is it that Indigenous peoples were able to shift attitudes toward them, where before the international system, the global system governments, did not recognize in any explicit way or in any formal way Indigenous peoples' rights at the international level. There were laws, of course, at the domestic level, but the reason Indigenous peoples went internationally was because those domestic laws, those national laws that existed, were not sufficient. How is it that Indigenous peoples managed to achieve this recognition on the global scale? Did they have political clout? No, not really. Was it economic power? No. My thesis is that it's the power of ideas, the power of the ideas that they put forward, seizing upon basic concepts that resonated throughout the world and that are understandable by the broader world, global society. So the power of ideas is an idea, the power of ideas that Indigenous peoples invoked had to do with what I would describe as 5 interrelated human rights concepts. And these 5 interrelated human rights concepts can be seen built upon or as foundational to the UN Declaration on the Rights of Indigenous Peoples. 1, equality. The basic idea that we see represented in so many documents, including the Declaration of Independence. We hold these truths self-evident, that all men are created equal. An idea that resonates across the globe, that has its grounding in Western civilization as well as civilizations in other traditions. And an idea that has evolved. It is not just men that are deemed to be created equal today. It is men and women. And it is not men and women of the European denomination that are deemed to be equal. It is also others as well from different cultural backgrounds. And Indigenous peoples took this idea and evolved it even further from the idea of individual equality to one of equality that takes into account group identity. The classic liberal notion of equality hadn't really worked that well for Indigenous peoples. What did it mean in the mid-20th century? It was admitted by most governments, by then, although not before, but most governments across the globe by the mid-20th century admitted that Indigenous peoples, yes, are equal. At least the individuals who are members of Indigenous communities are equal. But what would that mean for most countries? Assimilation. They're equal, hence they should simply become the same as everybody else, entitled to the same rights. Now for many, that itself was an achievement because there had existed rank discrimination against Indigenous peoples by which they suffered conditions of slavery, or at best, conditions in which they did not have full rights of citizenship and access to the basic services of the country. In Australia, Indigenous peoples were not citizens across the board until the 1960s. In the United States, it was until the 20s that Indigenous individuals enjoyed across the board rights of full citizenship. So many would say that that was an achievement in and of itself, And I think it was, that indigenous individuals were regarded as equal to all others. But that notion of equality that prevailed in the 1920s was one that led to an ethic or a philosophy of assimilation. The idea that indigenous peoples should simply join the broader society as individuals, citizens with the same rights and no different status than others. But through the advocacy of indigenous peoples and this movement that I've described, we see this notion of equality evolving further. One, as I mentioned, that is based on recognition of group identity. So equality is not simply the right to be like all others, or not even primarily that right. It's the right to maintain that distinct identity, just as the majority is able to maintain that identity of the majority culture. Take language, for example. The right to equality in that context doesn't mean the right to speak English as all others. It means the right to speak one's own language under conditions that are appropriate to that particular culture. Other cultural attributes can be seen in the same way. And so equality was looked at by indigenous peoples and promoted by indigenous peoples as a matter of not just individual equality within a presumptively broader homogeneous society, but as a matter of equality taking into account that distinctive identity. Cultural survival. Once equality is admitted to mean that indigenous peoples have the right not just to be regarded as individuals, as others within a broader society, but to have their own cultures respected as all others, then the idea of cultural survival comes into play. The idea that indigenous peoples, like all others, should be able to maintain all those aspects that make them, their societies, their particular communities, unique. Just as the majority culture is able to exercise its culture and all those aspects of its identity that make it what it is. Indigenous peoples similarly are entitled to do that. This notion of cultural survival. And it was promoted and eventually became accepted in a robust sense, so that culture meant not simply being able to maintain aesthetic characteristics that correspond to diverse indigenous communities, such as dress, or to maintain language alone, how important that is. But culture was understood in a robust sense to include those relationships that indigenous peoples have with land and resources, including water resources. To the extent that indigenous peoples' own cultural identities and cultural patterns are related to the use of these resources, to the extent that these natural resources are part of indigenous cultural identity, rights to the resources were seen as part of this cultural survival and linked and implicit to this idea of cultural survival. Property. The notion of property was one that historically had been used against indigenous peoples. John Locke, the philosopher John Locke, said that in order to perfect a property interest, one has to use the land intensively. So unless that land is cordoned off and used intensively, such as the way the European settler farmer would do, it was really no one's land and could be acquired by those who would put it to such predictive use. So, thus conceived, property was, as I said, an enemy for indigenous peoples because the concept provided a justification for taking indigenous peoples' land under this view that indigenous peoples were not using the land productively and had not perfected a property interest in it. Again, indigenous peoples through advocacy turned this idea on its head and said, no, if property means the ownership of something that one has reduced to one's legitimate control, that one has a connection with in a legitimate sense, then our own ways, if we take the notion of equality and culture seriously and infuse that with property, then our systems of property need to be respected on an equal level as the dominant systems of property. And so we see that idea permeating throughout the various international institutions in which indigenous peoples' rights are being discussed and eventually being accepted. The Awastini case, again, that went to the Inter-American Court of Human Rights, was a case that was based on the general human right to property. The case was filed in the 1990s. It was about a community that was faced with a logging concession on its territory. The government had granted a concession to a Korean multinational company to take valuable resources within its territory. upon the view that the land was government land. Why? Because the indigenous community concerned, Awastini, didn't have a title to that land. They weren't using the land intensively. They said the land was there, but the government said, no, they don't have a title. We don't see them out there farming every inch of this land, so it's our land. That's literally what the government said, the government of Nicaragua in this case. When we filed the case before the Inter-American Human Rights Institutions, there was no Declaration on the Rights of Indigenous Peoples. There was not yet an instrument that recognized Indigenous peoples' collective rights over lands and resources that was binding upon Nicaragua. But Nicaragua was and continues to be a party to the American Convention on Human Rights, which recognizes the right of everybody to his property. And those are the words used. Everyone has the right to his property. And so it was on that basis that the claim was filed. And the interpretation of property that was advanced was that property viewed in a multicultural context, in light of this norm of cultural survival, in light of basic precepts of equality, must be understood in light of indigenous people's own property systems, in light of indigenous people's own land tenure systems. And the court upheld that interpretation of this general right to property. And so now we see this idea of property again being turned in favor of indigenous peoples. It's not an entirely new idea, just like equality and culture aren't new ideas. But these are ideas that are rooted in human rights understandings, but then are seized by indigenous advocates and indigenous peoples to affirm their own rights according to their own conceptions of those particular rights. Self-determination. This is another idea well rooted in the Western liberal tradition. The idea that individuals and groups should be able to control their own destinies. The idea of self-determination is seen as grounded indeed in the American Revolution and the French Revolution. President Woodrow Wilson around the time of World War II championed self-determination as a way of addressing the claims of different groups or different states and minority groups in Europe. Self-determination became the basis for the decolonization movement in the mid-20th century, the basis by which colonies in Africa, Asia, and elsewhere became emancipated in independent countries. Indigenous peoples took this basic idea of the right of everybody, individually and collectively, to control their own destinies, to not be dominated by others, seized upon it, connected it with their own institutions of self-governance, their own traditional institutions of self-governance. It was a basis by which to tell the stories about how they had been denied participation in larger systems of government, about how their own institutions of self-governance, their own political institutions of self-governance, had been suppressed in various ways. And it was the basis by which to affirm that right, to maintain that inherent sovereignty that indigenous peoples claim. It's a very contentious idea as it was deployed in the context of the drafting of the UN Declaration of Indigenous Peoples because of its connotations linked with independent statehood. But what the indigenous rights movement really emphasized to the world is that at bottom, self-determination is not about attributes of statehood. As a human right, it's about that essential right of everybody across the board, across the globe, all human beings, all of humanity, to be in control of their own destinies and to have the institutions of government within which they live devised accordingly. And what indigenous people shown was they weren't in control of their own destinies. Governments had taken control of their lands and resources and were managing their own lands and resources. And the institutions of government were not responsive to their own aspirations. So the basic idea of the human right of self-determination does not necessarily mean the creation of new states. It means the nuanced creation of its institutions that are responsive to that ability, to that desire of indigenous peoples to maintain control of their own destinies. And the way the different institutions may be developed might vary or will vary across the globe given particular contexts. So the right of self-determination became featured in the UN Declaration on the Rights of Indigenous Peoples. It's affirmed in Article 3 of the Declaration. All indigenous peoples have the right to self-determination, Article 3 says explicitly in the Declaration on the Rights of Indigenous Peoples. And of course it's understood as being a right that doesn't imply the formation of new states, of new countries, secession. That would be not a responsive solution for most, if not virtually all, indigenous peoples across the globe. The idea of self-determination, though, became central to the indigenous rights movement and it's an essential component of the normative regime that developed as represented by the UN Declaration on the Rights of Indigenous Peoples. Then the idea of economic and social justice. Through their advocacy at the UN Working Group on Indigenous Populations and elsewhere, it became apparent that there were multiple pathologies the indigenous peoples faced within their communities. Poverty. It became clear that across the globe, almost without exception, indeed as a characteristic of indigenous peoples, they were at, and continue to be, at the lowest socioeconomic rung in the socioeconomic ladder. In terms of all the indicators one can point to, health, formal education, income, and so forth, indigenous peoples typically are at the bottom. High rates of suicide, high rates of violence, particularly against women. All these pathologies can be seen and were shown to the world to be characteristic of many or most indigenous communities. But it was also shown that this isn't because indigenous peoples in some sense are simply inferior to others. These conditions are the legacy of the history that indigenous peoples have suffered, and this became evident through this indigenous rights movement. And the idea that this shouldn't be, that there should be social justice and economic justice in the face of this history came to resonate. And so that within the Declaration on the Rights of Indigenous Peoples, we see the social and economic concerns of indigenous peoples being addressed. And the Declaration hence calls upon states to address in a robust way these particular concerns. So equality, cultural survival, property, self-determination, social economic justice. These are 5 core ideas that became part of the indigenous rights movement, that the indigenous rights movement seized upon and built upon in order to achieve this recognition of their rights as reflected in the UN Declaration on the Rights of Indigenous Peoples. Now, it all sounds really nice, right? Find this recognition on the part of the global community expressed in the UN Declaration on the Rights of Indigenous Peoples. But I probably don't need to tell you that if we look across the globe, we probably see these rights more honored in the breach than in the respect for them. We see the Declaration representing still more of what isn't the case for indigenous peoples as opposed to what is the case. We see these rights to lands, resources, equality, rights to culture, in very many places across the globe, still not respected. And so we see this enormous challenge of implementation before us now. We see the enormous task that someone needs to seize upon in order to move conditions for this segment of humanity towards a condition of realization of those rights that have been affirmed. Why is it that we have this persistent, what has been called an implementation gap? And numerous examples could be given about this implementation gap. Don't really have time to go into them now. But this implementation gap exists. Why is it? What are the factors underlying it? Well, here are a few. Lack of awareness among public actors, among government actors. When I was the United Nations Special Rapporteur on the Rights of Indigenous Peoples, part of my work, or an important part of my work, was to sit down and meet with government actors, not just in Geneva at the United Nations or in New York at the United Nations. I would do that, but that's meeting with the diplomats whose job it is to represent their countries before the international community. But I frequently traveled to the countries and I would meet with government officials at all levels, beginning, in some cases, heads of states, very frequently ministers or department heads. But I would always try to meet with the public officials who were actually working day to day and on the ground in functions that are close to indigenous people's lives, such as the people who operate the health services, people who operate educational services, individual or public officials who work in natural resource management. And what I saw in virtually every country I visited, including the United States, Canada, and other countries, was an ignorance about Indigenous peoples' issues and about their rights. So individuals in charge of water management systems saw Indigenous peoples as, well, maybe they're there, but not really contemplating how they should or could participate in water systems management, or not fully understanding what their presence meant for those water systems, the water management systems, what their rights based on treaty or otherwise were, and what those rights implied for their water management strategies, for example. I found this to be the case in so many different countries, in so many different contexts. I remember sitting down with the Minister of Education in Namibia, and she simply insisted that Indigenous peoples had education like all others, ignoring the data that another ministry of the government, another agency of the government, the one in charge of Indigenous affairs generally, or what they call marginalized communities, had given me that showed very low levels of formal education among certain Indigenous groups. I mean, this was something that she just simply wasn't familiar with in her particular work, and this is the ministerial level. I could give countless examples of where, among public officials, simply a lack of awareness about Indigenous peoples and their rights as they're conceived of today at the global level. This acceptance of Indigenous peoples' robust rights, collective rights, including rights over lands and resources and self-determination, in many ways simply has not seeped down at the operational level among governments. Then, of course, there are competing economic and political forces. Across the globe, we can see competition over natural resources, for example, water resources, mineral resources, oil and gas resources. And by and large, it's the powerful economic and political actors that are in control of the exploitation of these resources, including when those resources are found on Indigenous peoples' land. Many of the remaining deposits of oil and gas in this world and of valuable mineral resources are on Indigenous peoples' territories. But for the most part, the control over those resources is not in Indigenous peoples' hands. Powerful economic and political forces are at play that create enormous tensions against efforts to recognize and implement Indigenous peoples' rights over those very same resources. And then there's simply regulatory inertia, where we have regulatory regimes, land management regimes, for example, that have been in place for decades that really don't take into account Indigenous peoples' rights, say their rights, their cultural heritage rights, their concern over sacred sites, don't take into account fully their treaty rights to hunt or their inherent rights as Indigenous peoples to maintain that connection with their traditional territories. Regulatory regimes are created in ways that don't account for these rights and don't function to include them in the considerations that feed into decision making by the public actors. And to change these regulatory regimes is often very difficult. And so simply the inertia that exists counts against or operates against the implementation of Indigenous peoples' rights. Now, underlying all of this, I think there's a fundamental problem of social attitudes that are at best ignorant and in many ways adverse toward Indigenous peoples' rights. There is a sense of otherness of Indigenous peoples, the sense that Indigenous peoples really aren't part of the body politic, that they are something other in the U.S. as real Americans. They are something of the past or something that's outside of modernity. And this attitude towards Indigenous peoples that we see in the use, for example, of mascots by certain sports teams, the Washington Redskins mascot, for example, really perpetuates this sense of otherness of Indigenous peoples, the sense that there's something out there. They're not really part of real society, of real American society. That's very much present, and that operates very strongly as a force against the effective recognition and implementation of indigenous peoples' rights. Now, there are two variants I see of this sense of otherness, of these social attitudes that exist towards indigenous peoples. One is that of seeing indigenous peoples as the vanquished savage who stood in the way of development. Under this view, indigenous peoples really don't exist anymore. And I'm sure many of you have had experiences or know of or can tell of anecdotes by which members of the dominant society reflect this attitude of thinking of indigenous peoples as no longer present in any relevant way. Yes, there might be an indigenous individual you know here and there, but there might be reservations way out there, even if they're not really way out there, they're only a few miles away, but they're really not present. And Indians are these vanquished people that really aren't present in today's society. Charles Dickens, the British novelist, reflected this attitude. He was one of the most influential writers in American society, even though he was from Britain. He said, "My feeling is that if we have anything to learn from the Indian, it is what to avoid. His virtues are a fable, his happiness a delusion, his nobility nonsense. We have no greater justification for being cruel to the miserable object than for being cruel to a William Shakespeare or an Isaac Newton. But he passes away before an immeasurably better and higher power, i.e. that of Christianity, than ever ran wild in any earthly woods. And the world will be all the better when this place knows him no more." This is Charles Dickens projecting. And this is what people today think really was or should be the case, that we know him no more, the Indian no more, the vanquished savage. The other variant is of the noble savage. Well, Indians are here, but they're this noble person. They're represented by this noble person who lives one with nature, an idealized individual. And different projections are made upon the noble savage, the most common one being that individual who is one with nature. The noble savage is embraced under this variant of thinking, but that embrace nonetheless keeps the savage distant. The savage isn't part of modernity, isn't part of society. In the 1970s, some of you, I remember, there was a public announcement spot. What do they call these PSAs, public service announcements, that ran on television. And in that public service announcement, there was this actor dressed as an Indian. He actually turned out to be an Italian-American fellow, Iron Eyes Cody, paddling down a river, pristine river. Then he gets to a city, gets closer to the city, sees pollution, and then the announcement goes, "People make pollution. People can stop pollution." And then camera pans to this noble savage, and a teardrop goes down his cheek. And that's supposed to tug at the hearts of the American public. This is the better part of this notion of otherness of indigenous peoples. Yet it permeates, I would argue, and I do argue, American society today and the societies of many places. The idea that indigenous peoples are not really present in modern society. They're part of the vanquished past, the past that included a series of obstacles among which indigenous peoples were one, just like the natural environment that was conquered by settlers. And indigenous peoples are part of that vanquished past. The other variant, the noble savage, well, they're still here perhaps, but they're still apart. There's these people that have this nobility about them, but they're still something other than the mainstream. And so what I think that fundamentally is required for these norms to be implemented is not more international institutions, not more international treaties, not some international police force. We would never have that anyway. But what is a precondition for these human rights standards concerning indigenous peoples to be implemented is for there to be greater public awareness that embraces understanding indigenous peoples as part of contemporary life, seeing them not simply as part of the vanquished past or something noble to be venerated but kept apart, but part of contemporary life, that embraces a common cross-cultural identity. What do we think of when we think of American culture, so-called American culture? Well, it's not indigenous culture. Isn't that odd? Isn't that strange? I've always, growing up, I remember how strange it was when we'd study about the America and then we'd talk about the Indians, and as if these were two different things. And I was always made to feel like I was not really American. And I was part of this other. And I think there needs to be constructed a cross-cultural identity. I know among many Native peoples, there's a sense, well, it's our culture and it's been dumped upon so much. So there's a reluctance, understandably, to share that culture. But I really think that there needs to be greater cross-cultural sharing, including from indigenous peoples to the broader society. That does happen to some extent, but perhaps it could occur more in a more decided way, such that the national symbols of this country and other countries could include the symbols of indigenous culture. We see that in certain countries. For example, New Zealand. We see politicians, the mainstream politicians, opening each of their speeches in a public setting with words in Maori, which is the language of the native peoples of that country. Now, New Zealand is full of problems, and one could say that that was simply window dressing, but it's window dressing, and with that symbolism, steps can be accelerated towards real respect for rights. Where the majority can take a stake in indigenous cultures, I think that there's all the more chance that that majority will come to cherish indigenous culture and work to genuinely advance and allow for its protection by indigenous peoples themselves. So I think there needs to be this public awareness that embraces a common cross-cultural indigenous identity. And then, importantly, the mainstreaming of education about indigenous peoples. Education about native peoples in this country is ghettoized for the most part. If you want to learn about indigenous history, if you want to learn about indigenous culture, you don't take a history class for the most part. You don't take simply a class on culture more broadly. You go and take a class specifically in the American Indian Studies program on, or its equivalent, on indigenous peoples in particular. And then you go in that class, and you look around the room, and everybody looks the same or talks the same, or already has the same ideas about what they should be thinking. There isn't in the mainstream educational system, for the most part, a robust consideration of indigenous peoples' culture. I could give innumerable examples in legal education. Take intellectual property, for example, a very rich field of law. And my colleagues, who are very expert in intellectual property, several of them, are ignorant about what is happening within the World Intellectual Property Organization addressing indigenous people's particular concerns about their cultural heritage and how those concerns raise very complex issues of intellectual property that can and should be and will ultimately have to be addressed by the mainstream. My field, international human rights, one looks at most international human rights textbooks and that won't really feature indigenous people's concerns. Or if it does, there will be a chapter on it. All these cross-cutting issues of human rights that indigenous peoples have raised and shown to be relevant to the broader field of human rights aren't present. Now, in my textbook, of course, on international human rights, I and my co-authors try to do that, to mainstream issues of indigenous peoples, women, minorities, and other kinds of issues throughout the curriculum on international human rights teaching. Constitutional law. is a field that touches upon indigenous peoples in very many ways. We have the so-called Indian Commerce Clause, which is one of the main clauses of the Constitution, main sources of power for the federal government in the Constitution. That is one of the main bases for the power of the federal government to treat or deal with indigenous peoples. But in our legal education on constitutional law, that clause is by and large, and I would say almost always or always ignored in a classic constitutional law case. Even though it is part of the Commerce Clause more generally, which is addressed exhaustively in legal education, the power of the government to regulate commerce among the states. But that clause says commerce among the states with the Indian tribes and with foreign nations. That's the power of the government, to regulate commerce among the states with the tribes and with foreign nations. Yet the part with the tribes is not at all addressed in your basic common constitutional law class. You have to take an Indian law class, and then you learn about the Indian Commerce Clause. Our legal education ghettoizes indigenous issues. Our primary education, our primary school education, high school education, and basic college education does the same. How can there be a broader societal awareness and understanding of these issues if these issues are taught as something that is apart from the mainstream, that doesn't have relevance to the mainstream? And so there needs to be, starting with the primary levels of education, elementary education, a mainstreaming of history, a mainstreaming of culture about indigenous peoples, a mainstream education about the history and culture of indigenous peoples. Now, as I've pointed out the problem of implementation, it is quite daunting. And I have said, and I said when I was UN Special Rapporteur in one of my reports to the UN Human Rights Council, that my fear was that there would be a complacency developed within the international community toward this state of affairs, by which we have a beautiful instrument recognizing indigenous people's rights, but yet these rights not being respected on the ground. And this complacency would be manifested by people coming together, government representatives, non-government organizations, experts of all kinds, academics coming together periodically and lamenting this implementation gap, lamenting that, oh yes, things are not so good. And that complacently would be the norm into the future. And so I urged for some kind of definitive action, concerted action, and very thought through strategy toward addressing this implementation gap. And in doing so, I said we should look back to the indigenous rights movement and see what lessons that we can learn from its success to achieving the recognition of indigenous people's rights. This movement that had little political or economic power, if any, which was able to achieve the recognition of indigenous people's rights, has a lot to tell us about how those rights ultimately can be implemented. What I'd like to do is read for you part of the statement, my last statement to the United Nations in my capacity of Special Rapporteur, where I tried to lay out what I thought the main lessons of the indigenous rights movement and how those lessons are relevant to the future. First, the indigenous rights movement is and has been enlightening. It has been a force to enlighten and educate about the presence of indigenous peoples in the world today, about their conditions, aspirations, and contributions. A force to make known that indigenous peoples are not just historical figures to be relegated to images of savagery or romanticism. Indigenous peoples and their allies have used various means, including advocacy in the political arena, the media, the courts, academic platforms, and the arts and international forums, to raise awareness about the present-day manifestations of historical oppression that indigenous peoples continue to suffer, as well as about what they bring to the world's rich cultural mosaic and knowledge. This enlightenment has been an essential precondition for mobilizing social and political forces to recognize Indigenous peoples and their rights. Yet, as I found in my work as UN Special Rapporteur, there's still a great deal of ignorance in the world about Indigenous peoples, and that ignorance continues to breed attitudes that resist needed change. I'm convinced that more, broader, and deeper enlightenment and education are needed to bring about the kind of social and political climate that will yield more decisive steps toward operationalizing and implementing the rights that are embedded in the Declaration on the Rights of Indigenous Peoples. A second element of the Indigenous rights movement that has animated progress is a pragmatic tendency, a tendency to be pragmatic and constructive in the search for solutions that are grounded in fundamental principles. This principled pragmatism can be seen in the historical treaty making by Indigenous nations by which they sought to reach arrangements that were both respectful of their sovereignty and accommodating to the presence of European settlers. And it can also be seen at work when Indigenous peoples moved to gain access to the United Nations in the 1970s within existing limitations on participation, eventually to gain a permanent presence in the United Nations. Pragmatism and constructive problem solving will undoubtedly be a key to the success of continuing efforts to gain greater participation at the international and global level. And in more local settings, as Special Rapporteur, I saw numerous institutions in which Indigenous peoples have been able to use existing domestic legal arrangements to their advantage, despite flawed or weak aspects of those legal arrangements. And in doing so, build precedents and practices that are ultimately conducive to the exercise of their rights. In their pragmatism, Indigenous peoples and their allies have known to distinguish principle from dogmatism, to distinguish enduring truths and rights from the conventions and doctrine that are transient and circumstantial. They have been creative and open to building common ground for practical coexistence and amicable relations. And a third and final characteristic of the Indigenous rights movement I'd like to mention is its optimism. I believe optimism animated the Iroquois, or the Haudenosaunee chief Desgahe, whom I mentioned before, as well as the Maori leader Ratama when they traveled to the League of Nations in the 1920s with hopes of a response that would lead to justice for their peoples. Even though their efforts did not bear immediate fruit, that same optimism was present in subsequent efforts by Indigenous peoples to appeal to the international community. That same optimism allowed Indigenous peoples, once having gained a foothold in the United Nations, to propose and imagine a day when there would be a declaration on the rights of Indigenous peoples. And that same optimism now helps drive the multiple efforts across the globe in multiple settings to see the rights enshrined in the Declaration made reality in Indigenous people's everyday lives. And as I was welcomed into Indigenous communities in several countries during my time as Special Rapporteur, I learned of their struggles and challenges, but at the same time, amid the struggles, I consistently saw optimism that looks beyond the present to a better future, if only a distant future. So almost 7 years ago, after I'd been named Special Rapporteur on the Rights of Indigenous Peoples, the well-known and respected present-day Iroquois chief, Oren Lyons, he came up to me, this was at the UN, and he says, Jim, there's been a lot of progress, but there's a lot of work to do. There's a lot of work to do. But, he said, the wind is on our back. The wind is on our back. And so, 7 years forward, I still think the wind is on our back. Thank you. Take questions?
Thank you, Jim. Yeah,
Yeah.
we have time for some
Yeah,
questions.
sure, yeah.
So feel free to ask Professor Anaya questions.
Yes.
When you talk about intellectual property rights of tribal folks, what are some of the challenges that we're seeing in the legal realm?
There are a number of them. I'll just name one in particular that comes to mind is this notion of the public domain. That has operated against indigenous peoples being able to retain control or justly benefit, equitably benefit from their creative or cultural expressions. So art forms, such as songs, visual arts and so forth, have been appropriated because under the dominant view, something that cannot be identified with a particular author is in the public domain and hence can be taken and used freely. And of course, indigenous peoples' art forms and cultural expressions cannot be, by and large, identified with a specific person. These are art forms, expressions that have developed over generations, if not over centuries. And so this notion of public domain is operated very much against indigenous peoples being able to benefit from their cultural expressions and traditional knowledge. Those are the kind of things we see. We could see the same kind of thing in traditional knowledge about genetic resources, the same things about with regard to medicinal or plants with medicinal qualities that pharmaceutical companies identify and then will take as their own because an indigenous group doesn't have a particular individual who's gotten searched for a patent, him or herself. And so numerous problems in this realm have developed. The World Intellectual Property Organization is now engaged in a discussion to address these issues and is attempting to develop new instruments that will likely take the form of a treaty to in some way protect these traditional cultural expressions and traditional knowledge and genetic resources. But there's a lot of controversy about these efforts still. Yeah.
What do you see for the prospects, mechanisms, or time frame for implementation of the UN Declaration of the United States?
It's going to be ongoing, and I think that if this is somewhat, I've said this before, and I'll probably be misquoted again, but I think the reason we have the Declaration is because these rights have been violated, right? If they have been enjoyed all along, there wouldn't be a need for a declaration. But I think there's always going to be a need for a declaration. And the day we don't need a declaration anymore, this whole concept of indigenous peoples is going to go away. We're just going to have peoples. Just have the Quinault, the Navajo, the Haudenosaunee, without this notion of indigenous peoples, because the whole notion connotes groups that have suffered historical oppression and for whom special initiatives and protections are required. But I think because of the vulnerabilities of particular groups across the globe, typically characterized indigenous peoples, there's always going to be a need for some kind of action and protection of a remedial sort. So it's an ongoing project. But if we look at specifics, say we look at poverty rates among indigenous peoples, or something like violence against indigenous women, I think there are particular goals that can be achieved in our lifetime in that regard. So that maybe poverty isn't eliminated entirely, but at least that enormous gap that exists between indigenous communities and the majority society can be reduced or eliminated. Violence against women in particular won't be eliminated, but at least that enormous gap that exists now. It's astounding that how much more likely, this is Justice Department figures confirm how much more likely indigenous women are to suffer rape in their lifetimes than non-indigenous women. If we see, and that's just one example of the violence that we see indigenous women suffering, and if we could see that gap reduced, not by non-indigenous women suffering more, but by less suffering by indigenous women, then I definitely think that's possible. Those kinds of things are possible. I think that a lot of the issues we see around sacred lands, for example, I don't know why land management practices can't be better attuned to cultural heritage sites of indigenous peoples. Why there can't be greater sensitivity. Why always the economic value of a piece of property has to win over indigenous people's cultural sites. It's not like indigenous peoples themselves are saying, okay, we don't want to develop these lands at all. That's not happening. It's just that indigenous peoples our target are very, very much aware of what is sacred and what can be exploited. The mainstream society understands the notion that certain areas are off limits, and we have national parks. And for the most part, those are protected, and those are regarded as off limits to certain kinds of development. But somehow when it comes to indigenous peoples, it's, oh no, they're against development, which is just not true. It's just not true. We see indigenous peoples engaging in mining activities, engaging oil and gas extraction, industrial fishing, yet that goes with protecting the resources and with protecting sacred areas and cultural sites and areas of cultural significance. And so I think there's more understanding about these issues, that very practical measures can be taken to address them by the national government, say the Bureau of Land Management, the Fisheries Department, and for example, and state level agencies as well. Yeah.
So I teach in the School of the Environment in Pullman here at WSU, and all three of my classes that I teach on a regular basis have elements of what you talked about tonight, because I think it's very, very important for anybody being trained in natural resources and the environment to know some of this. Two issues arise. I'd really like to get your perspective on these two in the minds of non-Indian students. One is based on kind of a Lockean rugged individualism. Each of us, starts out at birth with the same chances, so the argument goes. Why should a particular group be given any particular extra consideration just because something happened to their grandfather? That's one argument we get time and time again. The second issue that arises that is really a challenging one is we know, for example, the Treaty of 1855, a lot of land was retained by the Nez Perce people, for example, in our part of the world. The Treaty of 1863 shrunk that by some 80 or 90%. So students will ask the question, okay, we stole this land.
It's fair and square.
Right.
Stole it fair and square, yeah. I heard that a lot, yeah.
Right, but even the ones who don't add that say, so what now, 4 generations hence, should we do? Should we give it all back?
Yeah.
If this were a just world, what should we do? Those are questions that are very challenging to
Yeah, they are, but they're not. I think if you turn those, into you took out the indigenous element and you asked the same question, someone's grandfather came to Iowa, and their farm was taken from them 2 generations ago, they would continue to see themselves as in some way entitled to recover or have some form of redress for that taking, especially to the extent that that taking 2 generations or however many generations can be perceived as committing or manifesting itself in an ongoing wrong. Now, certainly there comes a time when intergenerational wrongs dissipate, and that if we tried to unpack, say, most of the world, Europe, for example, and we tried to unpack how all the conquest among the different kingdoms and monarchies and feudal entities transpired over time, that'd be impossible. You could never achieve historical or distributive justice or remedial justice there. But that's not what we're talking about here. We are talking about wrongs that manifest themselves in contemporary pathologies and contemporary inequities. And those are present. The fact that indigenous peoples are impoverished is not because they're just inferior to all others and don't know how to work. Many people like to think that. It's because their resource base, land base to sustain their communities was taken from them. It's because their cultures were undermined. The social structures that are linked and embedded in those cultures were attacked and were severely stressed. And so these high suicide rates and other kind of social pathologies we see in indigenous communities are very much directly related to this. And this isn't just my musing. I mean, fortunately, now we have sociologists who have studied this in depth and can show these direct linkages. And it's not like the only remedy necessarily is to return the land to indigenous peoples. That's, we need practical solutions, but we need equitable solutions. Take the Black Hills, for example. Those were stolen fair and square from the Sioux Nation, right? And I mean, there's not even a dispute about it. That's what's amazing about it. I mean, there's not even a dispute that it was just a treaty was violated, and the U.S. just came and said, no, we'll forget it. We found gold, so we're going to go and we're going to take it. That's not even a dispute. But now it's like, oh no, we can't give it back. We got to keep it for the, we're going to even chisel, the faces of 4 dead folks, American presidents up there. And they want to put another one up there every time someone likes a president who passed away. So, it's like you have to add insult to injury by doing that. Now, why is that the case? Why can't the Black Hills be a place of cross-cultural connection? Why does it have to be a place of defeat for Native peoples? And I say this in jest, we stole it fair and square, but that is the attitude. We stole it fair and square, so forget about it. We defeated you. We defeated Native Americans. We conquered them, so that's it. And conquest makes right. Now, why is that? If it weren't Native Americans, that wouldn't be an American, right? American is the land of the free, the just, and all this kind of stuff. But somehow, it's this sense of otherness that allows mainstream America to think that way. It is a problem, and these are exactly the attitudes, precisely. I'm not attributing to you, and I'm not saying that you hold them yourselves, and I'm glad you raised them, because what you're illustrating is they are prevalent today. You're illustrating, again, how these attitudes are prevalent. But they come from a series of assumptions that have to do with seeing Indigenous peoples, to begin with, as the other, not as people who really are part of the fabric of society. So the Black Hills, in my view, the solution isn't to give it back. Now, I know that's, many would insist on that, but there is a time again when we come in history when expectations shift, equities shift, and we have to recognize that. But the equitable balance isn't simply adding insult to injury to that theft, as in my view is done now. It's to come to an understanding that that land is and continues to be sacred for the Lakota people and other Sioux people. And to come to some mechanism where that sacred character can be lived out by those to whom the land is sacred. And that isn't a difficult proposition. That is, in a practical sense, that wouldn't be difficult to do. Now, the National Park Service in an area not far from the Black Hills has actually moved in that direction by developing a co-management regime for an area of National Park Service lands by which the Oglala Sioux tribe is able to participate in the management of the park. And that's in order for them to regain that connection or reestablish that connection with that territory. There are all kinds of arrangements that can. I mean, it's astounding how I was part of an effort to try to get the birthplace of Geronimo recognized in the Gila Wilderness, which is an area that growing up we knew that this is where Geronimo's birthplace was. But the Park Service just fought tooth and nail for having that recognition there. To have Geronimo's birthplace recognized would not be consistent with the myth of defeat of the Apache and that people, and that still lives today. That still lives. Here's where the Apache were driven out of and defeated, and to sort of have this place then come alive again as a place that reflects Apache heritage is just too much for some reason. And why? Because it's the others, the defeated savage, that is projected upon the Apache people, and not this sense of identity with them. So it's how do you unpack that? How do you address that? And I totally agree, it's very difficult. I've given a few ideas. If we start at an elementary school, perhaps. Greater education and greater dialogue. And it's got to be a real dialogue. A lot of us who talk about minority rights, Indigenous rights, we become very strident, and we become very judgmental off the bat. And there's not enough understanding from that end either. And I think that there needs to be a more, there needs to be a greater effort to convey these things in a way that's really understanding of the prejudices that exist and why those prejudices exist. They're really a matter of ignorance. One more question.
I'm a doctoral student in community and cultural research, putting together a tribally based definition of intellectual property and making some recommendations for the protections, and based on the declaration, that that we can do that. So I have a lot of questions, but I'll just stick to a couple of points. One of the things that I've been wondering about in looking at the declaration and some of the books that are written about it and stuff is that the poverty of words in trying to use one language to address things that belong to a culture that has different languages, and so like the idea of rights versus responsibility. And so if the people from the Sioux Nations have a right to the Black Hills, in their language maybe it's more a responsibility to the Black Hills, and I kind of think of that as in relationship to intellectual property too, where we have a right to define intellectual property. Well, we have a responsibility to define intellectual property for ourselves, and so to me that makes more sense for my tribe, that when I go to them and ask them to talk about what intellectual property is so that I can do a discourse analysis of that material and put together a definition that, to me, it makes more sense that we talk about it as responsibility. And so if you think of land, giving land back or allowing people to fulfill their responsibility to that land or that water or something, maybe, I don't know if the people at the United Nations or in those special working groups considered that or addressed it in any way. And the practical question I have is, when President Obama signed off on the declaration, I'm pretty sure I saw a presidential proclamation that asked agencies within the United States to respect the principles in the document, but I can't find that anywhere. Do you know where I could find that?
Okay, first, as to the first one, you're absolutely right. The poverty of language, that's a great phrase, and that certainly exists. The Declaration builds upon this notion of rights because that is embedded within the UN system, and so it's a way of, it's a foothold that allows for the discussion of these issues. But I think that in order to give full consideration to these rights that are articulated as such, one needs to understand the responsibilities aspect of them, and the points you're making about that, certainly I have heard pressed by Indigenous leaders within the international arena, but it's something that always needs to be recalled, that is an important part of these rights or go hand in hand with them, or that the notion of rights really incorporates responsibilities. There isn't a specific presidential proclamation. There's a statement that the State Department issued parallel to President Obama's statement that says that should happen and that will happen, and the President himself in his statement said that it should happen, but we don't have a formal directive to that effect. That was one of the recommendations I actually made when during my time as UN Special Rapporteur. I made that recommendation to the United States, but as far as I know, it hasn't been taken up. And it's not because I recommended it, but it's because it's the right thing to do. So that my suspicion is that's why you haven't found it, because what there is, though, is like I said, there's the presidential statement itself, and then there's the statement by the State Department, which lays out the U.S. Rationale behind the endorsement of the declaration and what it is supposed to mean. It's supposed to, the declaration, according to that statement, is really supposed to reflect and provide an impetus for the furtherance and strengthening of U.S. policy towards Native peoples, and it's supposed to provide a gloss of understanding about U.S. policy, so that U.S. policy is supposed to be read against the declaration. I wish federal agencies were more aware of that, but unfortunately they're not. It would be useful if there were a directive going specifically to the agencies, the various departments and agencies, making that point. But and then there's there's actually an apology, a congressional apology that was included. We always see these bad things go into appropriations bills, right? People talk, oh, they snuck that into the appropriations bill. But there's actually an apology to Native peoples of the country by Congress, signed by the President, it's there, but it's buried deeply in an Defense Appropriations Act. Never saw the light of day because of that, but it's there. It's there, and I think more use needs to be made out of that. Anyway, thank you very much.
Yeah, thank you very much.